State v. Ouimette, case number 23 AP 377. Representing the appellant, James Ouimette, is Sarah Starr. Representing the appellee, State of Vermont, is Andrew Gilbertson.
Thanks very much, and good morning, everybody. We'll hear from counsel for the appellant first. Of course, please identify yourself and your client and then proceed.
Good morning, Your Honors. I'm Sarah Starr, and I represent the appellant, James Ouimette.
Thank you.
This case is remarkable in that now on appeal, the state concedes that the words that the appellant was alleged to have spoken, which constituted a true threat, were actually never uttered by the defendant at all. And so the record is clear, and the state agrees that the complaining witness here said that Mr. Ouimette pulled up to a stop sign and said, "I could shoot you right now." He made no threatening gestures. He was not alleged to have a weapon. And this statement, as shown in the record on appeal, is not a true threat. Indeed, saying that one could do something is commonly understood as an expression of frustration or exasperated overstatement, as in, "I'm so tired, I could die," or something to that effect. But what the state charged and argued repeatedly and very forcefully to the jury and to the court was that Mr. Ouimette told the complainant, "I am going to shoot you," in the which is just a vastly different statement. And so,
Ms. Starr, I hate to interrupt you, but but there was also a gesture that was undisputed that he made. You put it in your brief that he, I think you quoted, "flipped them off," is what you stated in your brief. So does that factor into it as well? I mean, there's obviously some aggression between the two parties.
I mean, there's case law that says that giving somebody the finger isn't a true threat. There was no correlation between the statement, "I could shoot you," and the giving somebody the middle finger. There was no shooting gesture. There was no movement towards anything threatening. It was certainly offensive, but that's not the standard for a true threat under the First Amendment. And what happened in this case just didn't pass that bar. And the fact that we know now on appeal what the actual words were, that it was not a direct threat, the court should take this opportunity to correct an error that really goes to the heart of the case when the crime itself is speech. And we know the speech didn't occur as the jury was instructed. There needs to be a correction, and the case should be reversed.
And the standard here is plain error, is that correct?
Well, I think, the defense counsel did repeatedly argue that it didn't rise to that level. The problem was that the error was so pervasive and it shows really, I think, even if the defense counsel didn't identify the exact statement, it just shows like how prejudicial the error was. So even if it is plain error, it reaches that bar because it goes to the heart of the crime itself. I mean, other plain errors might be collateral to the actual charge, but here the error lies in the actual criminal speech. And that is what really, I think, makes this case remarkable and really mandates that there be a new trial. And if there's no other questions, I'll reserve my last minute.
Okay, fine. Thanks very much. We'll hear from the appellee. Please introduce yourself and your client and then proceed.
Good morning, Your Honors. My name is Andrew Gilbertson, and I represent the state of Vermont. We'd ask the court affirm Mr. Ouimette's convictions. And as explained in the state's brief, the standard of review here is plain error. and as explained in the briefs, that none of the errors that the defendant has set forth rise to the level of a plain error or a miscarriage of justice. So with that, I will accept any questions from the court.
So, does the tone matter? I mean, the way it was, words were spoken, the gesture that was part of the case, can those be factored in by the jury in making a determination whether or not this is a crime or a protected speech?
I think they can, because the standard is that it's the context of the words that are spoken to determine whether or not they're a threat. And so the jury heard about the context of a relationship between Mr. Ouimette and Mr. Samau. They heard of the testimony about the gesture and the statement that Mr. Ouimette made, and they concluded that it was a threat.
So go ahead,
I'm
Chief.
sorry.
Sorry. No,
Oh,
go ahead.
all right, thanks. Do you agree that the words that were uttered were "could shoot you" and is in your line of reasoning that's sufficient?
Yes, Your Honor. That was what the transcript says. Mr. Samau said, "I could shoot you in the head." He also said later that he considered that a threat to shoot him in the head.
And do you think, Mr. Gilbertson, that given the history between the defendant and the complainant or victim, that Mr. Ouimette could be criminally convicted for the words he did not say as well, just given that history between the two of them?
I'm sorry, could be convicted of the words he did not say?
Not say, yeah. Like he said, as Ms. Starr has argued, I mean, he essentially said, look, I could shoot you, but that could be equated to someone saying, I'm so tired, I could die.
I think that either one, as a matter of law, could constitute a threat considering the context of their relationship.
So the relationship does matter as to the words that are spoken. I mean, the shared driveway creates some friction between the two, and that can be considered.
Yes, the jury can hear the whole context and understanding that what Mr. Ouimette said was a threat.
Okay. Anything else?
No, thank you very much, Your Honors.
All right, thank you. How much time does the appellant have, please?
Appellant has 55 seconds remaining.
Counsel?
Thank you. I disagree with the idea that we can take the words out that were alleged to be the threat and just look at the context. I agree that words in context matter, but that doesn't mean that the words themselves don't matter. And so I think that it would be very dangerous to say after the fact that these are the same words and the jury would have reached the same conclusion if a different crime had been charged, because this was the crime that was charged. These were the words that were criminalized, and this is a very specific question, and it should not be taken out of the hands of the jury, and it should be, if it does, as a matter of law, still rise to the level for to survive a Rule 29 motion, the prejudice to the jury of hearing the wrong words and being able to weigh the context was overwhelming and requires a new trial. And so the case should be reversed. Thank you very much.
Starr, I'm sorry for interrupting you, but when you say it was overwhelming, are you essentially saying the cumulative effect of the mistake here that you argue the court made?
Yes, I mean, it's clear that because it was repeated so often and it was in the charging documents, that was what the court and pretty much everybody understood was the crime charged and the thing alleged. But the record shows that that's just not, it didn't happen. And so we know now that it didn't happen. And so it would be a miscarriage of justice to uphold a conviction for something that we now know didn't happen. So I think it's very simple.
Thank you.
Okay. Thank you. Thank you.